Judgment in the matter of R on the application of Gibson versus Secretary of State for Justice.
Lord Reed will give the judgment to the court.
When a person is convicted by the Crown Court of a criminal offence, a confiscation order can be made requiring him to pay the value of the benefit that he has gained from his criminal activities, so far as he has assets from which that sum can be realised. The Crown Court also fixes a prison sentence to be served in the event that he fails to pay the amount ordered, in addition to any sentence imposed as a punishment for the offence. If he fails to pay the amount ordered, then the Magistrates Court issues a warrant committing him to prison. If by the time of commitment he has paid part of the amount ordered but not the whole, he has to be committed to prison to serve only part of the sentence which the Crown Court fixed in default. In broad terms, a proportion of the default sentence is deducted, which corresponds to the proportion of the sum due which he has paid. So, for example, if he has paid a quarter, the default sentence is reduced by a quarter. Similarly, if he makes further payments while he's serving his sentence, more time is deducted from the default sentence by the prison governor on the same basis. But a complication arises from the fact that the amount ordered to be paid bears interest. The problem is illustrated by the present case. Mr. Gibson was convicted of drug trafficking and sentenced to 25 years imprisonment. He was also ordered by the Crown Court to pay more than £5 million by way of a confiscation order within a year, or serve an additional 6 years imprisonment in default of payment. By the time that magistrates issued a warrant for his committal for non-payment, the amount outstanding had risen because of interest from £5 million to £8 million. In the meantime, he had made a part payment. The question which then arose was whether the time to be served should be reduced according to the proportion that the part payment was of £5 million or the proportion that it was of £8 million. It was decided that the reduction in sentence should be based on the proportion he had paid of £8 million, which meant that he was given a smaller reduction in sentence than he would have been if the calculation had been based on the figure of £5 million. He later made further part payments, and the prison authorities again calculated the reduction in the time that he had to serve on the basis of a proportion he had paid of £8 million. The issue in the appeal is whether, under the extremely complex legislation governing this question, interest ought to be included in the calculation. The courts below held that the legislation meant that it should be. The Supreme Court unanimously allows the appeal against that decision and holds that interest should not be included. The legislation under which the confiscation order was made was the Drug Trafficking Act of 1994. At the relevant time, it provided that where the Crown Court ordered a defendant to pay an amount under a confiscation order, the order was to be enforced as if that amount was a fine imposed by the Crown Court. Fines imposed by the Crown Court are treated for enforcement purposes as if they had been imposed by magistrates. The magistrate's power to commit an individual to prison for failure to pay a fine is set out in the Magistrates Court Act of 1980. Section 79 deals with part payments. It provides that where after a period of imprisonment has been imposed in default of payment of any sum, payment is then made of part of the sum, the period of detention is to be reduced in the proportion that the amount paid bears, and I quote, to so much of the sum as was due at the time the period of detention was imposed. The courts below proceeded on the basis that the period of detention was imposed when the Magistrates Court made the order committing Mr. Gibson to prison for non-payment, by which time interest had brought the sum due up to £8 million. But in a confiscation case, the period of detention is imposed when the Crown Court fixes the period to be served in default of payment. That follows from the statutory definition of what imposing imprisonment means, and it's also a matter of agreement between the parties to this appeal. At the time the period of detention was imposed by the Crown Court, no interest was due, as that was the very time when the Crown Court made the confiscation order. No time had elapsed during which payment was overdue, and therefore no interest had accrued. The sum due at that time was £5 million, not £8 million. It is argued that that cannot be how the legislation was intended to operate, but straining of the wording of legislation cannot be justified where it would adversely affect the period of imprisonment to which a person is subject. Penal legislation, particularly legislation imposing penalties that deprive liberty, is construed strictly. The natural construction of the section is that the starting point for the calculation of reduction in days of imprisonment is the sum outstanding at the time of a Crown Court order, in this case the £5 million. The appeal is therefore allowed.
The court will adjourn.